Chapter 7 Crimes and Business. Classic case. This Supreme Court decision illustrates how a business can violate a criminal statute. Businesses, like individuals, have some protection from police searches and seizures. The business here contended that the search of its premises was unconstitutional, but the court disagreed. New York v. Berger. Facts. Joseph Berger is the owner of a junkyard that dismantles automobiles and sells their parts. 5 officers of the Auto Crimes Division of the New York City Police Department entered Berger's junkyard to conduct an inspection pursuant to New York Vehicle and Traffic Law 415-A5. The division conducts 5 to 10 inspections each day. The officers asked to see Berger's license and his record of the automobiles and parts in his possession. Berger replied that he did not have a license or record. The officers then announced their intention to conduct a 415-A5 inspection. The officers checked the vehicle identification numbers of several vehicles and determined that some were stolen. Berger was arrested and charged with possession of stolen property and operating as an unregistered vehicle dismantler. Issues. Is the warrantless search of an automobile junkyard unconstitutional, or does it fall within the exception for administrative inspections of highly regulated industries? Is an administrative inspection unconstitutional just because the ultimate purpose of the regulatory statute is the deterrence of criminal behavior and the inspection may disclose violations of the criminal code? Holdings? No. The search is constitutional because an automobile junkyard is a highly regulated industry. No. The fact that the statute was intended to deter criminal behavior and the inspection may disclose crimes does not make it unconstitutional. Reasoning. Excerpts from the opinion of Justice Blackmun. The court has recognized that the Fourth Amendment's prohibition on unreasonable searches and seizures is applicable to commercial premises. An expectation of privacy in commercial premises is less than a similar expectation in an individual's home. There is even less expectation in closely regulated industries. Because the owner or operator of commercial premises is in a closely regulated industry, has a reduced expectation of privacy, the warrant and probable cause requirements have lessened application. This warrantless inspection, even in the context of a perversely regulated business, will be deemed to be reasonable only so long as 3 criteria are met. First, there must be a substantial government interest that informs the regulatory scheme pursuant to which the inspection is made. Second, the warrantless inspections must be necessary to further the regulatory scheme. Finally, the regulatory statute must perform the 2 basic functions of a warrant. It must advise the owner of the commercial premises that the search is being made pursuant to the law and has a properly defined scope, and it must limit the discretion of the inspecting officers. To perform the first function, the statute must be sufficiently comprehensive and define that the owner of commercial property cannot help but be aware that his property will be subject to periodic inspections undertaken for specific purposes. Searches made pursuant to 415-A5 clearly fall within this established exception to the warrant requirement for administrative inspections in closely regulated businesses. First, the nature of the regulatory statute reveals that the operation of a junkyard is a closely regulated business in the state of New York. The provisions regulating the activity of vehicle dismantling are extensive. An operator cannot engage in this industry without first obtaining a license, which means that he must meet the registration requirements and must pay a fee. The operator must maintain a police book recording the acquisition and disposition of motor vehicles and vehicle parts, and make such records and inventory available for inspection by the police or any agent of the Department of Motor Vehicles. The operator must display his registration number prominently at his place of business, on business documentation, and on vehicles and parts that pass through his business. The person engaged in this activity is subject to criminal penalties as well as to loss of license or civil fines for failure to comply with these provisions. That other states besides New York have imposed similarly extensive regulations on automobile junkyards further supports the closely regulated statutes of this industry. An administrative scheme may have the same ultimate purpose as penal law. Even if its regulatory goals are narrower, New York, like many states, faces a serious social problem in automobile theft and has a substantial interest in regulating the vehicle dismantling industry because of this problem. The New York penal laws address automobile theft by punishing it or the possession of stolen property, including possession by individuals in the business of buying and selling property. The state has devised a regulatory manner of dealing with this problem. Section 415-A serves the regulatory goals of seeking to ensure that vehicle dismantlers are legitimate business persons and that stolen vehicles and vehicle parts passing through automobile junkyards can be identified. The discovery of evidence of crimes in the course of an otherwise proper administrative inspection does not render that search illegal or the administrative scheme suspect. Finally, we fail to see any constitutional significance in the fact that police officers, rather than administrative agents, are permitted to conduct the 415-A5 inspection. Many states do not have the resources to assign the enforcement of a particular administrative scheme to a specialized agency. So long as a regulatory scheme is properly administrative, it is not rendered illegal by the fact that the inspecting officer has the power to arrest individuals for violations other than those created by the scheme itself. Introduction. Why should a business law textbook contain a chapter on criminal law? The reason is that businesses are constantly confronted with the effects of crimes such as computer crimes, embezzlement, and forgery. As can be seen in the classic case, a business can be subjected to police searches and business owners can commit crimes. To prevent a crime from happening or to deal effectively with a crime once it has occurred, you need to know what constitutes a crime and the legal consequences of criminal conduct. You also need to be aware that social media is changing some aspects of criminal law. Social media can make it easier for criminals to locate victims, such as the thieves who use postings to target burglary victims or who befriend children to target kidnapping victims. The criminal law developed through a long history of precedents. However, most states have codified their criminal laws. As you should expect, the exact rules vary from state to state. Begin by referring to Exhibit 7.1 on page 162, which summarizes the primary distinctions between civil law and criminal law. Try to distinguish between the two areas throughout this chapter. Remember that one action or series of actions may constitute both a civil wrong and a criminal wrong. Generally, the civil suit will occur independently of the criminal suit. Some jurisdictions permit civil and criminal matters to be joined into one lawsuit. It will also be helpful to look at Exhibit 7.2 on pages 162 through 163, which examines the 6 steps in a typical criminal proceeding. Crimes versus torts. It is important to remember that one act can be the legal basis for both a criminal lawsuit and a civil lawsuit. The two separate suits will not be barred by either the doctrine of res jurisdicta or by the rule against double jeopardy. In many situations, a criminal act, an act against the rules of society, will also involve an infringement on the legal rights of an individual. If one act is both a crime and a tort, it may be prosecuted by the criminal system, and the injured individual may be available to seek remedies in the civil system. For example, the state of California prosecuted O.J. Simpson for the death of Nicole Brown Simpson. Her relatives sued him for the tort of wrongful death. Objectives of criminal law. The objectives of criminal law are the protection of persons and property, the deterrence of criminal behavior, the punishment of criminal activity, and the rehabilitation of the criminal. Protection of persons and property. Someone once said that a lock was designed to keep an honest person honest. It is for the same reason that the government declares certain conduct to be illegal. The government believes that all persons and their property should be protected from harm. The primary difference between tort law and criminal law is that tort law may result in money damages being paid by the actor to the individual victims, while criminal law may result in loss of freedom by sending the actor to jail or prison. Private interests are served through the awarding of damages. The public interest, on the other hand, is served by punishing criminal activity. If all persons respected everyone else's person and property, there would be very little reason for criminal law. However, there is evidence that they do not. There's an old saying in fraud prevention circles called the 10-10-80 rule. 10% of people will never steal, 10% of people will steal at any opportunity, and the other 80% of employees will either weigh depending on how they rationalize a particular opportunity. Deterrence of criminal behavior. One method used to reduce criminal behavior is to present a sufficient deterrent to antisocial behavior. The presumption inherent in criminal law is that if we make the punishment sufficiently harsh, people and businesses who contemplate criminal behavior will avoid it because they fear punishment. If people fear the punishment, they will not commit the criminal act. If a sufficient number of people fear the punishment, there will be a reduction in that crime. The severity of the punishment is often an issue with corporate defendants. What constitutes a substantial penalty for an individual would be a minimal penalty for a corporation such as UBS Bank. Criminologists have noted that severity alone is not a sufficient deterrent. Individuals considering criminal behavior may also believe that they are likely to be identified and punished. The deterrent effect is reduced when criminals believe that they will not be identified, tried, or found guilty. The U.S. Constitution states that there shall be no cruel and unusual punishment. If U.S. law allowed the death penalty for even minor offenses, there would probably be fewer minor offenses. But is that just? Most people would argue that the loss of one's life for stealing a loaf of bread seems too high a price to pay for fewer loaves of bread being stolen. Similarly, many feel that canning a teenager for vandalism or castrating a rapist is too extreme. The problem is to decide how much punishment will deter criminal behavior without being deemed excessive and unconstitutional. Punishment of criminal activity. Society cannot deter all criminal activity, so the U.S. legal system accepts that a certain level of criminal activity will exist. Accordingly, we punish criminal activity for punishment's sake. If a criminal takes something without paying for it, the criminal law makes that individual pay for it through deprivation of freedom for a period of time. Convicted criminals can be imprisoned, sentenced to probation, fined, or subjected to criminal forfeiture. Criminal forfeiture is when the government confiscates property as a punishment for criminal activity. Rehabilitation of the criminal. The criminal justice system does not end with punishment. The U.S. government has designed various programs to educate and train criminals in legitimate occupations during their incarceration. Theoretically, then, criminals should have no reason to return to a life of crime. Sometimes a sentence is suspended. That is, it is not put into effect. In such cases, the court supervises the individual's activities to ensure that they have learned from their mistakes. Seriousness of the offense. Criminal law classifies offenses into categories according to their level of seriousness. These categories are, from least to most serious, infractions, misdemeanors, felonies, and treason. First, infractions. Some states or local governments have a separate category for petty offenses called infractions or violations. Infractions are the violation of a rule or a local ordinance. They are generally punishable only by fines. Some examples include illegal gaming and breach of the peace. If a college fraternity party becomes noisy, the police may be called for breach of the peace. Misdemeanors. Misdemeanors are minor offenses that are punishable by confinement of up to 1 year in a city or county jail, a small fine, or both. Public intoxication, speeding, texting while driving, and vandalism are likely to be classified as misdemeanors. Felonies. Felonies are major offenses punishable by confinement from 1 year to life in a state or federal prison, a large fine, or both. In some states, special capital felony statutes provide for the sentence of death. Murder, arson, rape, burglary, and grand theft are normally classified as felonies. Treasons and sedition. Treason is the only crime defined in the U.S. Constitution and is the most serious offense against the government. It is currently defined as whoever, owing allegiance to the United States, levies war against them or adheres to their enemies, giving them aid and comfort within the United States or elsewhere, is guilty of treason and shall suffer death, or shall be imprisoned not less than 5 years and fined. not less than $10,000, and shall be incapable of holding any office under the United States. Treason is based on the concept that the person owed either a perpetual or temporary allegiance to the United States. Every citizen of the United States owes perpetual allegiance to it. Aliens who are domiciled in the United States own temporary allegiance to it. If a citizen mutters words of discontent, the words by themselves will not constitute treason. The general view is that the treason requires an overt act or a confession in court. The overt act does not have to be a crime by itself. The purpose of the overt act requirement is to show that the accused actually gave aid and comfort to the enemy. However, the overt act can be the oral or written communication of an idea, such as conveying military intelligence to the enemy or broadcasting radio shows of support and encouragement for the enemy. Sedition is an agreement, communication, or some other activity intended to incite treason or some lesser commotion against the public authority. It includes advocacy intended and likely to incite or produce imminent lawless behavior. Sedition may be committed by taking some preliminary steps, as compared to treason, which requires an overt act. If the plan is for some minor disturbance, then, even if the plan is actually completed, it will be sedition instead of treason. Elements of a crime. Generally, an individual is presumed innocent until proven guilty. The government has the burden of proving that the suspect is guilty beyond a reasonable doubt. Beyond a reasonable doubt is proof to a moral certainty. There is no other reasonable interpretation. Technology can make it easier for the government to catch the suspect or prove its case. For instance, observers may take videos of the fight or get-away vehicles with their cell phones. The government must prove all the elements of the crime. There are two primary elements in every crime. In order for the defendant to be found guilty of an alleged criminal act, the state must prove that both elements are present to the degree specified in the state's criminal statute. The state must prove beyond a reasonable doubt that the defendant committed the prohibited criminal act and that the defendant possessed the necessary mental state at the time the act was committed. The wrongful act is called the actus reus, and the state of mind required for each crime is called the mentis rea. If only one element is present, no crime exists. For example, if you decide to embezzle from your employer and then take no steps to implement your decision, you have not committed a crime. The intent was present, but no prohibited act occurred. Similarly, if you are smoking in a motel and your cigarette ignites the draperies in your room and causes a motel fire, you have not committed the crime of arson. A prohibited act occurred, but there was no criminal intent. In the latter case, you may be liable for negligence, but you have not committed arson. Even if an actor has committed a prohibited act and possessed the necessary criminal intent, no conviction will occur unless the state can convince the jury of both elements beyond a reasonable doubt. Note that the jury does not find the defendant to be innocent. Rather, the defendant is found not guilty. The jury decides that the state did not satisfy its burden of proof in the case. The act. The law generally imposes criminal liability only when an individual acts in a manner that is prohibited by law. Ordinarily, the prohibited act must be voluntarily committed by the person before criminal liability will attach. This means that a person who is forced to act illegally against his or her will does not act voluntarily and may not be legally responsible for the act. However, the court may still impose liability if it decides that the threat used to force the conduct was not sufficient to remove the free will of the actor. Some situations may require an individual to act or respond to the circumstances in a particular way. In these situations, a failure to act may be deemed a criminal action, sufficient to justify prosecution by the government. This responsibility to act may be imposed by a statute, as it was in the classic case, or by judicial precedent. Mental state. To be held criminally responsible for an illegal act, the actor must intend to do the act. The terms commonly used today to describe intent are 1. Purpose. An actor acts with purpose if it is his or her conscience objective to perform the prohibited act. 2. Knowledge. An actor acts with knowledge if the actor is aware of what he or she is doing. 3. Recklessness. An actor acts with recklessness if he or she disregards a substantial or unjustifiable risk that criminal harm or injury may result from his or her action. 4. Negligence. An actor acts in a criminally negligent manner if he or she should have known that a substantial and unreasonable risk of harm would result from his or her action. 5. Strict liability. An actor will be held strictly liable if he or she acts in a manner that the law declares criminal, even if none of the above 4 elements is present. This intent is used primarily for crimes that have a light punishment, for example, violating food safety laws. This mens rea is also used in statutory rape cases simply because society has a vested interest in protecting its youth. Selected crimes and offenses. We are unable to list all of the common crimes and offenses in this text. We will mention selected crimes that have applications for either detection or prevention in the marketplace. In many situations, it is the business that is the victim of the crime, not its perpetrator. It is possible for a business to be the perpetrator of a crime, and there are a number of criminal statutes aimed primarily at business activities. Murder/manslaughter. Homicide is the killing of one human being by another. It is not necessarily a criminal act. It will not be a criminal act if killing was unlawful. For example, if there was a justification such as self-defense. Murder, however, is the willful, unlawful killing of a human being by another with malice, aforethought, deliberate purpose, or design. Manslaughter occurs where the killing is unlawful but without malice. Manslaughter is usually divided into 2 categories: voluntary, upon a sudden heat of passion, or involuntary, in the commission of an unlawful act, or in the commission of a lawful act without appropriate caution. It is common for the state to charge a defendant with both murder and manslaughter, and to let the decider of fact, the jury, if there is one, the judge, if there is no jury, determine which crime was actually committed. Corporations have been charged with manslaughter in a number of cases, including when a construction site accident killed 7 of the corporation's workers, when an employee died of cyanide exposure, and when a defective product accidentally killed the user. Arson. Arson is the intentional or willful burning of property by fire or explosion. Originally, this crime was limited to the burning of a house. In most states, the crime has been expanded to include the burning of all types of real property, land and items of property permanently attached to land, and many types of personal property, property other than land. Businesses may be the victim of arson in some cases. In other cases, a business person may commit arson by burning his or her business as part of a plan to defraud an insurer. Burglary. Burglary is the breaking and entering of a structure with the intent to commit a felony inside the structure. Originally, this crime was restricted to the breaking and entering of a house at night, but, like arson, it has been expanded to include other structures, such as stores and warehouses. The crime also is no longer limited to nighttime conduct, but can occur at any time of the day or night. In some states, the crime of burglary has been expanded to include burglary of a motor vehicle. Embezzlement. Embezzlement is the taking of money or other property by an employee who has been entrusted with the money or property by his or her employer. Businesses should establish practices and procedures to reduce the likelihood of being victimized by embezzlement. Forgery. Forgery is the making or altering of a negotiable instrument or credit card invoice in order to create or to shift legal liability for the instrument. It generally consists of signing another person's name to a check, promissory note, or credit card invoice, or altering an amount on any of those documents. The government must generally prove that the accused acted with the intent to defraud. A business entity should use care in maintaining checks and signature stamps. It should also reconcile bank statements to discover potential forgeries. A good internal control system can help deter forgery and embezzlement. Credit card and check legislation. Customers make extensive use of credit cards, debit cards, checks, and electronic payments. This poses a number of problems for businesses. For instance, criminals may steal an individual's credit card, debit card, or account number and use it to make substantial purchases. Card numbers may be obtained by accessing computer files where an owner has charged a purchase to his or her credit card. Copies of credit slips are also used to obtain numbers. There are also small machines that quickly swipe a card and retain the card information. Dishonest employees can obtain this information and then sell it to other criminals. Some states have enacted separate legislation making it a crime to misuse someone else's credit card or debit card without permission. Other states treat this as a type of forgery. Criminals may steal the checks of an individual or business and forge the signature on the checks. A different type of problem arises when the owner of a bank account writes checks when there are insufficient funds in the account. Most states have enacted statutes that make it a crime to write or transfer, make, draw, or deliver a check when there are insufficient funds in the account. These are commonly called bad check statutes. Some states require the mens rea that the suspect intended to defraud the recipient of the check before any criminal liability will attach to the conduct. Identity theft. Identity theft occurs when a thief steals personal information such as the name, address, social security number, and/or employment history, and then uses this information to access the victim's credit. The thief can obtain the personal information on the internet through public records, stealing mail from the victim's mailbox, or going through the victim's trash. Thieves stole the identity of a Homeland Security agent in Fresno, California. The officer left his pay stub and bank information in his vehicle. When thieves stole his car, they were also able to steal his identity. Hackers, outsiders who gain unauthorized access to computers or computer networks, may gain access to personal information through an individual's personal computer, an employer's computer system, the records of a business with whom the individual dealt, or a credit card company's records. And one day in November 2008, an international ring of hackers hacked into a U.S. credit card processor and stole $9.4 million. In some cases, the thief may actually work for a credit card company or a credit card department of a retailer. In some state or federal prisons, cheap inmate labor is utilized for various enterprises. In one case, the state was using inmates to process credit card applications, and some of the inmates were stealing personal information from the applications. Once the thief has obtained the information, he or she may apply for credit using the victim's name or may access the victim's accounts, such as bank accounts, retirement accounts, or social security accounts. Criminal fraud. Fraud is a broad term that covers many specific situations. The tort of fraud was discussed in Chapter 6. The English courts were very reluctant to criminalize fraudulent behavior. Over the years, legislation was passed in both England and the United States to overcome the historic view of we are not to indict one for making a fool of another. Today, most states have statutes that cover variations of what is generally called criminal fraud, false pretense, or theft by deception. Most states require proof of the following elements to convict a person of criminal fraud. The speaker or writer made a false statement of fact. The statement was material, that is, the statement would affect the listener's decision, the listener relied on the statement, and the speaker intended to mislead the listener. Note that the fraudulent party can be either the buyer or the seller. For example, suppose that a savings and loan creates the impression that certain real estate assets are worth $100,000 by distributing false appraisals to induce a person to invest in those assets. In fact, the assets are worth substantially less than the false appraisals show. The savings and loan and its officers could be found guilty of criminal fraud if an investor enters a partnership with the saving and loan involving the purchase, development, or investment in those assets. The federal mail fraud statute applies to fraud conducted at least in part through the mail. The federal wire fraud statute applies to frauds conducted in part using email, radio, telephone, or television. One type of fraud that has received a lot of notoriety recently is Ponzi schemes. Ponzi schemes are named after Charles Ponzi. However, he was not the first to operate such a scheme. In a Ponzi scheme, the money from later investors is used to repay early investors or to pay them dividends. The early investors generally receive a high rate of return, attracting other investors to join the fund. Generally, there is no real revenue producing activity or investment. Eventually, the scheme is uncovered when the financer cannot obtain sufficient new investment. Bernard Bernie Madoff was sentenced to 150 years in prison for the Ponzi scheme he ran. The government claimed that he operated the scheme for at least 20 years and caused $13 billion in net losses to investors. Pyramid schemes are a variation of Ponzi schemes. In a pyramid scheme, an investor commits a certain amount of money, $100 for example, to get into the program. Often the investment involves an exclusive territory for that investor to harvest. He or she then gets other investors to buy in at the same price, subdividing his or her territory to these investors, with part of their investment going to the original investor and the balance going to the originator of the scheme. This continues down the pyramid, with each successive level of the investors buying a smaller and smaller portion of the original territory. Some pyramids involve actual products to be sold, while others involve a product to be developed in the future. In either case, investors towards the bottom of the pyramid tend to lose the money they invested. Both Ponzi and pyramid schemes are crimes committed by the business or the business person. Larceny is the wrongful taking and carrying of the personal property of another without the owner's consent and with the intent to permanently deprive the owner of the property. The most common forms of larceny are shoplifting and pickpocketing. Larceny does not require the use of force. Larceny is a serious problem for retail businesses. Merchandise is often lost through shoplifting. In addition, if customers feel unsafe due to pickpocketing, they will avoid certain stores and shopping centers. At common law, the theft or a trade secret was not considered larceny. However, many modern statutes have changed that by recognizing the misappropriation of trade secrets as theft. Some of these are federal statutes, including the National Stolen Property Act, the Economic Espionage Act, the Mail Fraud Statute, and the Wire Fraud Statute. There are also state statutes that specifically deal with the misappropriation of trade secrets. Robbery. Robbery is a form of aggravated theft. It is basically larceny plus the theft to use force or violence. To be classified as a robbery, the aggressor must use violence or the threat of injury to place the victim in fear. The aggressor then takes something in the possession or the immediate presence of the victim. If the same property had been carried away without the use of violence or a threat of injury, the act would be larceny. Espionage. The Economic Espionage Act of 1966, the EEA, makes the theft of trade secrets a federal crime. EEA covers both domestic economic espionage, for example, by competitors, and the theft of trade secrets to benefit foreign powers. It was the first federal statute to provide criminal penalties for the misappropriation of trade secrets. Misappropriation of trade secrets is also called economic spying or espionage. The act makes espionage a federal crime punishable by 25 years in jail or a $25,000 fine for an individual offender. It also provides for fines of up to $10 million for companies found guilty. Under the EEA, almost anything can be a trade secret as long as the owner takes reasonable steps to keep it a secret and it has economic value because it is a secret. Computer crime. Advances in computer technology have led to new criminal activities. Companies like The Gap, Hitachi America, PeopleSoft, Playboy Enterprises, and 20th Century Fox each attract from 1 to 30 hacker attempts per day. With our increased dependence on technology, computer criminals can create extensive damage. The going estimates for financial losses from computer crime reach as high as $10 billion a year. But the truth is that nobody really knows. Almost all attacks go undetected, as many as 95%, says the FBI. In addition to civil liability for improper use, many states now recognize the following activities as computer crimes. 1. Unauthorized use of computers or computer-related equipment. This may include the use of business computers for personal projects, including homework and personal email. It also includes transferring software purchased by a business to a personal computer. 2. Destruction of a computer or its records. Computer viruses destroy or alter records, data, and programs. Annually, there are numerous virus alerts. Some are fakes and some are legitimate. Businesses expend significant resources to protect themselves from viruses and to correct the damage they cause. This includes a virus that infects the computers in a college computer lab and subsequently infects student travel drives and home computers. In 2012, the FBI warned that more than 252,000 computers worldwide might be affected by the DNS changer, a virus that interferes with the computer's ability to properly process domain names. The virus was planted by a fraud ring which intended to redirect computers to its own servers. 3. Alteration of legitimate records. This would include altering a student's grade record in the registrar's office. 4. Accessing computer records to transfer funds, stocks, and other property. This would include entering a bank's computer system and transferring funds without authorization. For example, in 1994, Citibank discovered that Russian hackers made $10 million in illegal transfers. Initially, the bank called in a private security firm. When Citibank finally spoke to the FBI and the media, it lost some of its top customers. Competitors lured customers away from promising them that the competitors' computer systems were more secure than those of Citibank. Congress enacted the Federal Counterfeit Access Device and Computer Fraud and Abuse Act of 1984 to strengthen state attempts to deal with computer crime. The crime criminalized the unauthorized knowing use or access of computers in the following ways. 1. To obtain classified military or foreign policy information with the intent to injure the United States or to benefit a foreign country. This would include accessing classified Pentagon files. This constitutes a felony under the Act. 2. To collect financial or credit information, which is protected under federal privacy law. This would include accessing credit card accounts to obtain credit card numbers and credit limits. 3. To use, modify, destroy, or disclose computer data, and to prevent authorized individuals from using the data. This would include intentionally transferring a virus to a computer. 4. To alter or modify data in financial computers that causes a loss of $1,000 or more. This would include the unlawful transfer of funds. 5. To modify data that impairs an individual's medical treatment. 6. To transfer computer data, including passwords, which could assist individuals in gaining unauthorized access that either affects interstate commerce or allows access to a government computer. This would include the use of a sniffer program, which can hide in a computer network, record passwords, and then transfer this information to others. The first category listed above constitutes a felony, and the remaining 5 categories constitute misdemeanors. One way criminals access cell phones, computers, and tablets of victims is by embedding viruses in applications that the owners purchase or download for free. Another technique is war drivers, drive-by hackers who hack into wireless computer networks from streets or parking lots to obtain information and/or plant sniffer programs. Often the goal is to obtain credit card and debit card numbers to sell on the black market. A ring of hackers who hacked into the computers of Marshall's department stores and its subsidiary TJ Maxx stole up to 45 million credit and debit card numbers. The attack cost the parent company more than $130 million to settle with banks and customers. Corporate liability for crimes. Originally, courts held that a corporation could not be held responsible for crimes because the corporation was not authorized to commit crimes, and so lacked the power to commit them. Some states define their crimes in terms of a human being. For example, homicide may be the killing of one person by another. There is a growing trend in many states to hold corporations criminally responsible when their officers and agents commit criminal actions in the execution of their duties. This trend is evidenced by court decisions, statutory law, and the Model Penal Code. A specific example is the California Corporate Criminal Liability Act, which increased the criminal liability of corporate managers. Corporate directors, officers, and employees are also personally liable for crimes when they commit while acting for the corporation. It can be difficult to convict a corporation of some crimes because the government has to prove the mental state necessary for the crime. Corporate liability is more common when the corporation is accused of violating a statute that is mala prohibita, wrong because it is prohibited. In contrast, when the crime requires a specific mental state, such as battery with intent to kill, the courts generally refuse to hold the corporation liable unless the corporation itself participated in the acts or a high-ranking official participated in the acts with the intent to benefit the corporation. In some states, corporate liability is limited to white-collar crime. Although this term does not have a precise meaning, it generally means crimes committed in a commercial context by professionals and managers. The officers and agents can be tried separately and convicted for their behavior. When liability is imposed against their corporation, punishment is usually in the form of a fine. RICO, Racketeer Influenced and Corrupt Organizations Act. The RICO statute was included as part of the Organized Crime Control Act. Congress intended to remedy a serious problem: the infiltration of criminals into legitimate businesses is both a cover for their criminal activity and as a mean of laundering profits derived from their crimes. For example, Mark has a profit from his sales of illegal drugs. He approaches Maddie about investing in her restaurant. He becomes a partner in the legitimate business. Mark now receives his profits by check. He can report them on his tax returns without arousing suspicion. Sometimes the drug dealer will also use the restaurant as a distribution site for his drugs. RICO makes it a federal crime to obtain or maintain an interest in, use income from, or conduct or participate in the affairs of an enterprise through a pattern of racketeering activity. Criminal prosecutors and plaintiffs' attorneys soon recognize the opportunity to use RICO against commercial enterprises. Plaintiffs' attorneys are involved because the statute permits individuals who are injured by a violation of RICO to file a civil action. Successful plaintiffs in a civil action may recover treble damages, attorney's fees, and reasonable court costs. For example, beneficiaries of group health insurance policies use RICO to sue the insurance company. This is an example of the overlap between criminal and civil law systems. A prior conviction in a criminal suit is not required in order to file a civil RICO suit. Some critics argue that this is leading to unfounded lawsuits and out-of-court settlements by intimidated firms. The government can also file civil RICO actions where the burden of proof will be lower. High civil penalties can provide a lucrative law enforcement technique. Under RICO, persons employed by or associated with any enterprise are prohibited from engaging in a pattern of racketeering activity. A pattern is committing at least 2 racketeering acts in a 10-year period. These racketeering acts are called predicate acts. Racketeering activity has been broadly defined and includes most criminal behavior, such as bribery, antitrust violations, security violations, fraud, acts of violence, and providing illegal goods or services. Michael Milken was convicted under RICO of scheming to manipulate stock prices and of defrauding customers. Racketeering acts also include acts related to the Currency and Foreign Transactions Reporting Act, which is discussed later. RICO violations are added to other criminal charges when there is a pattern of corrupt behavior, such as bribery. Defendants may raise issues of double jeopardy when they are tried for both the predicate acts and RICO violation. Courts generally decide that the prohibition against double jeopardy is not violated because the predicate acts and the RICO offenses are separate and distinct crimes. Individuals convicted of criminal RICO violations can be fined up to $25,000 per violation, imprisoned for up to 20 years, or both. RICO also provides for the forfeiture of any property, including business interests, obtained through RICO violations. The property will be forfeited even if the property or business itself is legitimate. The defendant's assets can be temporarily seized before the trial begins to prevent further crimes. Some states have enacted their own RICO laws. Since the federal RICO law can be applied to legitimate business activities, it presents a potential concern for all business organizations, public and private. Currency crimes. The Currency and Foreign Transactions Reporting Act is a federal statute passed to prevent money laundering and to require the filing of currency transaction reports, CTRs. A currency transaction report is a report businesses must file if a customer brings $10,000 or more in cash to the business. The Uniform Law Commission, ULC, has written the Uniform Money Services Act of 2000 for adoption by state legislators. It enhances enforcement of existing money laundering laws and provides a framework for dealing with non-depository providers of financial services. Non-depository providers offer services such as check cashing and currency exchange. While these businesses provide some financial services traditionally related to banking, they do not hold clients' deposits or provide other banking services. Defenses. The 4 classic defenses to criminal liability are duress, insanity, intoxication, or justification. Each is briefly discussed below. Duress. Duress exists when the accused is coerced into criminal conduct by threat or use of force that any person of reasonable firmness could not resist. Not all governments permit this defense. Those governments that recognize the defense vary with respect to the crime to which it is applicable. Generally, the three essential elements of the defense are: 1. An immediate threat of death or serious bodily harm. 2. A well-grounded fear that the threat will be implemented. And 3. No reasonable opportunity to escape the threatened harm. Insanity. Insanity exists as a result of a mental disease or defect. The accuser either 1. Did not know that he or she was doing was wrong, or 2. Could not prevent himself or herself from doing what he or she knew to be wrong. The exact definition varies from state to state. Some states do not permit the offense. Most states permit some versions of the defense. Generally, the defendant has the burden of proof. However, in some states, the government has to prove that the defendant was sane. This defense has been attacked for a variety of reasons, but the main complaint is that the definition is ambiguous. Although the defense is raised often, it is rejected in many of the cases in which it is raised. Intoxication. Intoxication may be either voluntary or involuntary. Voluntary intoxication is not a defense unless it neglects the specific intent required by a statute. For example, the crime of rape is said to require a general intent. Intoxication, therefore, would not be a valid defense. On the other hand, assault with the intent to commit rape is said to require a specific intent. For that crime, intoxication may be a valid defense. By contrast, involuntary intoxication generally is a good defense. Involuntary intoxication, for instance, can occur if one is forced to drink an alcoholic beverage against one's will or without one's knowledge. An example of the latter would be if Jason offered Tanya a soft drink and she accepted. Jason spiked the soft drink with drugs without Tanya's knowledge. The defense of intoxication is summarized in Exhibit 7.3. Justification. Justification exists when a person believes an act is necessary in order to avoid harm to himself or herself or to another person. The key to this defense is that whatever the person does to avoid harm must be lesser than the harm to be avoided. For example, sometimes property has to be destroyed to prevent the spread of fire or disease. An animal control officer may destroy a rancher's sheep to prevent the spread of disease. A pharmacist may dispense a drug without a prescription in order to save a person's life. Criminal procedure. Criminal procedure deals with the process in a criminal case. It is concerned with safeguarding society without unduly infringing on individual rights. The drafters of the U.S. Constitution were determined to avoid the excesses and abuses that had occurred under English rule. As a result, the Constitution contains numerous criminal procedure provisions and protections, among them the guarantees of due process, the proper exercise of judicial authority as established by general concepts of law and morality, and equal protection, the assurance that any person before the court will be treated the same as every other person before the court. At a minimum, the constitutional protections require that the defendant may not be subjected to unreasonable searches and seizures, may not be held subject to excessive bail, the posting of money or property for the release of a criminal defendant while trying to ensure his or her presence in the court at future hearings, is entitled to a speedy trial, must be informed of the charges against him or her, must be tried before an impartial tribunal, must be permitted to confront witnesses against him or her, cannot be compelled to testify against himself or herself, and may not be subjected to cruel and unusual punishment if convicted. In the United States, evidence obtained through an illegal search generally may not be used in court. This is called suppression of evidence. The law carries a presumption of innocence until the defendant is proven guilty. The burden of proof in a criminal trial is the heaviest burden in U.S. jurisprudence. The government must convince the jury of the defendant's guilt beyond a reasonable doubt, or the defendant must be acquitted. Legal disputes may arise between a suspect and the police who search the suspect's business, home, car, or person. Under the Fourth Amendment to the Constitution, people are protected from unreasonable searches and seizures. A search will be valid if any one of the following occurs. The search is properly conducted under a legal search warrant based on probable cause. The search is conducted without a warrant by officers acting with probable cause. In some situations, courts use a more reduced standard than probable cause. Common examples of the reduced standards are when an officer pats down a suspect because the officer is concerned that the suspect has a concealed weapon or the evidence is in a motor vehicle that could be driven away. The search is conducted with the permission of the owner of the property or a person with proper possession of the property, such as a tenant who rents an apartment. An emergency or exigent circumstance exists that requires police to enter onto the premises, such as a fire in the building. Once police are legally on the property, they may observe and act on any criminal behavior they see. Evidence obtained through an illegal search may not be used in court. This is called suppression of evidence. Sometimes a business is subjected to a search, as in our classic case. Another example would be if the Occupational Safety and Health Administration, OSHA, wants to search a business for safety violations. Sometimes the business wants to search an employee's locker, desk, or computer. The law in this area is very complex and depends in part on 1. Who is actually doing the search, 2. The employee's expectation of privacy in the area, and 3. The basis for the employer's suspicion. The law about search and seizure is evolving rapidly, especially in the area of government searches of computers and offices. A police officer acting with probable cause may arrest and accuse an individual of committing a crime, or the arrest may occur under a warrant issued by a judge. A police officer who has probable cause to believe that a crime has been committed or is being committed may take the suspect into custody without obtaining a warrant. If an arrest warrant is used, it may be issued by a judge based on probable cause. The judge may find probable cause to believe that a crime has been committed solely on the basis of a sworn written complaint that names the person to be arrested or adequately describes him or her. Once arrested and charged with criminal conduct, the accused should be given a preliminary hearing. Preliminary hearings are not required in most jurisdictions if there has been a grand jury hearing. A grand jury is a jury whose duty is to receive complaints of criminal conduct and to return a bill of indictment if the grand jury is convinced a trial should be held. At the preliminary hearing, a magistrate determines whether there is probable cause to proceed to a trial. The charges against the accused will be dropped if the magistrate decides that 1. There is no probable cause, 2. That there is not enough evidence to proceed to trial, or 3. That there is virtually no chance to obtain a conviction. Then the accused will be released from custody. Once the grand jury has issued an indictment, or the magistrate at a preliminary hearing has determined that probable cause exists, the accused is called before a court to enter a plea on an indictment or criminal complaint. At the arraignment, the accused is informed of the charges against him or her, and if necessary, the court appoints an attorney to represent the defendant. Many of the motions discussed in Chapter 4 can also be used in criminal trials. A common pretrial motion at this point is a motion for change of venue. In criminal cases, change of venue is requested if pretrial publicity was negative to the defendant. The defense counsel argues the location should be moved to ensure a fair trial for his or her client. The defendant enters a plea to the charges. If the plea is guilty or nolo contendere, no contest, a plea in a criminal proceeding that has the same effect as a plea of guilty, but that cannot be used as evidence of guilt. The court moves to the sentencing stage. If the defendant pleads not guilty, a trial date is set, and if appropriate, bail is set. If the court determines that the defendant is a flight risk, the court may refuse to set bail. For example, the district court judge determined that financier R. Allen Stanford, charged with operating a Ponzi scheme, was not eligible for release on bail. A criminal trial is similar to a civil trial in many respects. The stages of a civil trial are discussed in Chapter 4. At the trial, the government has the burden of proving its case beyond a reasonable doubt, and it must satisfy this burden under the established rules of search and seizure. Any violation of the rules of evidence will result in the exclusion of the improper evidence, and often the exclusion of the evidence will effectively undermine the government's case. When this happens, the defendant will be acquitted. Historically, U.S. courts have used 12 jurors in criminal cases. Federal courts continue to use 12, but a number of states use a smaller number. Some states do not require unanimous decisions. The Supreme Court decided that if a state uses only 6 jurors, their decision must be unanimous. When the jury is being selected, the court often selects alternate jurors. An alternate replaces a regular juror who is not able to continue on the jury. A jury may be sequestered. When a jury is sequestered, jurors are not permitted to return home during the evenings and weekends. The jurors are kept separate from the rest of society so that others will not influence their views. Jurors are generally not sequestered in civil cases. For example, in the O.J. Simpson civil trial, Judge Fujisaki rejected the plaintiff's request that the jury be sequestered, stating there was no precedent for sequestering jurors at public expense in a civil trial. If the jurors are deadlocked or are unable to reach a decision, it is called a hung jury. In 2010, Rod Blagojevich, former governor of Illinois, and his brother were tried for corruption. They allegedly attempted to get money or jobs in exchange for Barack Obama's former Senate seat. The jury convicted them of 1 count, but was unable to reach a decision on other 23 counts. The prosecutors announced immediately that they will retry them. This retrial does not violate the prohibition against double jeopardy. If the defendant is found guilty, the court moves to the sentencing stage. Sentencing is governed by legislative guidelines to some extent, but the guidelines are normally very broad and somewhat vague. A great deal of judicial discretion is usually involved in sentencing, especially for state crimes. Under current federal law, federal judges have much less discretion in sentencing for federal crimes than most state court judges. Federal judges rely heavily on the federal sentencing guidelines. Contemporary case. In the following case, Jones argued that the police search was unconstitutional. The Supreme Court discussed 2 distinct tests for the validity of a warrantless search: the traditional trespass to property test and the reasonable expectation of privacy test described in Katz v. United States. 389 U.S. 347 88 S. Court 507 of 1967. Notice that the court responded to the concurring justices, which it calls the concurrence. United States v. Jones. The Court of Appeals denied a writ of mandamus in N. Ray Jones, 2012. Facts. Antoine Jones was suspected of trafficking in cocaine. Agents obtained a warrant to install a global positioning system, GPS, tracking device on a Jeep Grand Cherokee registered to Jones's wife. Jones was the sole driver of the vehicle. United States District Court issued a warrant authorizing installation of the device in the District of Columbia within 10 days. Agents put the GPS tracking device on the Jeep while it was in a public parking lot in Maryland on the 11th day. The agents used the GPS to track the vehicle's movements for 28 days. It relayed more than 2,000 pages of data. The government admitted that it did not comply with the warrant. It argued that a warrant was not necessary. Issue. Was the use of a GPS tracking device a legal search or seizure under the Fourth Amendment? No. The use of the GPS was not legal. Reasoning. Excerpts from the opinion of Justice Scalia. The Fourth Amendment provides that the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. It is beyond dispute that a vehicle is in effect as that term is used in the amendment. We hold that the government's installation of a GPS device on a target's vehicle and its use of that device to monitor the vehicle's movements constitutes a search. The government physically occupied private property for the purpose of obtaining information. We have no doubt that such a physical intrusion would have considered a search within the meaning of the Fourth Amendment when it was adopted. Later cases have deviated from that property-based approach. For most of our history, the Fourth Amendment was understood to embody a particular concern for government trespass upon the areas, persons, houses, papers, and effects it enumerates. The Cott's reasonable expectation of privacy test has been added to, not substituted for, the common law trespassery test. What we apply is an 18th century guarantee against unreasonable searches, which we believe must provide at a minimum the degree of protection it afforded when it was adopted. The concurrence does not share that belief. It would apply exclusively Katz's reasonable expectation of privacy test, even when that eliminates rights that previously existed. We do not make trespass the exclusive test. Situations involving merely the transmission of electronic signals without trespass would remain subject to Katz's analysis. It might have been possible to use traditional surveillance of Jones for the 4-week period using agents and vehicles. That visual surveillance in public would be permissible.